So welcome to class number 5. We're going to do a prelude in this class with criminal law, and we'll go over to procedure in our next lessons, because criminal law, there's not much to talk about in American law. I think the procedure is more important to us, but still I think it really is just going to be going over some basic terminology. So obviously crime is the word we all know. It's the same word in Portuguese, but basically any illegal act that can result in imprisonment. Felony or misdemeanor. So felony basically is a serious crime, something that can be punished by up to more than 1 year of imprisonment, which is almost all crimes in America. And then misdemeanor would be something that's not very serious. So maybe disorderly conduct, that's a misdemeanor, if you're being loud at a bar and you cause some sort of confusion. The misdemeanor, some states used to consider DUI, so driving under the influence, or DWIs, which is driving while intoxicated, a misdemeanor. Most states now, I think, consider it a felony, but that's going to be obviously a big impact on the sentence that's given to the defendant. The intent, it's important because intent, it really is very different in America. There's this idea of conspiracy to commit a crime. So really the intent is very important. Basically, the knowledge that I'm trying to impart on the people watching is that criminal law in America is completely different. It's the one thing that I would say is very, very different. You can see the German influence here in Brazil really clearly when you study American criminal law. Not criminal procedure, but criminal law itself. Mens rea would be a Latin term for guilty mind. So basically, you have actus reus and mens rea, those are the two elements. You have a guilty mind and you actually do the thing, right? So the next thing here, actus reus being you actually do the thing, a guilty act. The statute of limitations. So don't go around saying prescription, it's statute of limitations. Basically the amount of time after you commit a crime that you can still be punished for it. It depends, it varies state by state. Most criminal offenses are in state codes, not in federal codes in America. So murder, rape, those things are usually in state codes. And then it's going to vary state by state what the penalty is and what the statute of limitations is. So for instance, some states have no statute of limitations at all for any crimes. Some have none for things like sexual assault. Some have none for homicide. And some have statute of limitations for all crimes. Obviously, they tend to be a lot longer than in Brazil. Probable cause. Basically, you have to make an arrest or a search. You have to have a probable cause. You can't just walk up to a random person without a warrant. If you have a warrant, then you don't need probable cause. And not, the warrant is only given on probable cause, but as the arresting officer, you don't need to have a probable cause yourself. The judge will decide that if the warrant is given. You can't just walk up to a random person and arrest them for no reason. So that would be excessive and it would be a violation of the Fourth Amendment. A Miranda warning is something that the police tells a suspect when they're taking into custody. So basically, you've seen that in the movies where a police officer handcuffs a suspect and they tell them, you have the right to remain silent, anything you say can and will be used against you. Usually though, it's not, the Miranda warnings are not given at the moment of the arrest. They're given before the interrogation, right? So you take the defendant to an interrogation room. Basically, you read the defendant his Miranda rights or their Miranda rights. And what that means is that everything they say after they've expressed the fact that they understand their rights can be used against them. What they say before that cannot. Because in the decision Miranda versus Arizona, the Supreme Court basically said this is an inherently unfair setting for the defendant to be in police custody. And there's a number of tactics and psychological tricks that the police use to basically get you to confess to anything, even without physical force. So that's why you have Miranda warnings. And basically, hopefully none of you will ever be arrested in the United States, but if you hear a Miranda warning, you best heed the warning and not say anything, right? So don't if the police warns you have the right to remain silent, then you should remain silent. In fact, there are decisions saying that anything you say after a Miranda warning, which could be considered exculpatory, meaning it could be used in your favor, is invalid, right? So everything you do say in a police interrogation can only be used against you, not in your favor. In bail, I talked about this. Basically, the amount of money, I think it was cut off, or other collateral a defendant has to provide for the court in order to be let go before the trial, right? So it's basically an incentive. Come back, stay here for the full trial, and you might get your money back. So you have misdemeanor or felonies, basically depending on their severity. And basically, they tend to be in a statute. And really, all you need is a rational basis for a criminal statute to exist. So this is something that is discussed in the decision Lawrence versus Texas. As long as the government has a legitimate purpose and a rational basis, they can criminalize whatever they want. There isn't this idea, that we have from German law, Rechtsgut and things like that. It's more of a, the government has the discretion, especially the state government, has the discretion to punish anything they see fit. So there's also federal crime statutes. That's what specialized agencies you've probably heard of before are for. So you have the FBI, which is just the Federal Bureau of Investigation. It's basically law enforcement officers on a federal level with jurisdiction all around the United States. And the DEA, which is the Drug Enforcement Agency, which is specifically for drugs. You also have the Tobacco Bureau and Firearms, and a bunch of other agencies which also have, the power to conduct these things. You have, for instance, the TSA, you have the Federal Marshal, so there's a lot of different crime enforcement agencies law enforcement agencies in the United States. When you're accused of a crime, you have the right to an attorney. That's one of the Miranda warnings, and it's one that is to be provided free of charge. So this was decided in the Gideon versus Wainwright case, which is part of the mandatory reading, that you have a Sixth Amendment right to be represented by an attorney free of charge in any criminal case brought against you, that includes the right to be, if you're at the police station and you're being interrogated, you have the right to consult with an attorney, and any attorney will tell you not to say anything. Plea bargaining, like I explained before, is a way to waiver your right to a jury trial by basically admitting your guilt with the prosecution, which is done usually by the district attorney's office. Basically, you admit your guilt, or you plead no contest to the charges in exchange for a reduced sentence. A lot of people criticize that because they think, it's not very good. You can't basically threaten people with an extremely long prison sentence or a death sentence and basically get them to admit to something that you couldn't prove in an actual court. But it's the remedy that the courts found to protect the Sixth Amendment without having hundreds and hundreds of jury trials all over the country. Basically, pleading guilty to crimes they did not commit, like I said. That's why it's controversial and really a problem with the American criminal justice system. So here I did a little comparison with the idea of nullum crimen nulla pena sine lege, which we know from German and continental European law and from Brazilian law. This isn't something that exists in the United States. This idea is applicable, like what I said with the First Amendment. Really, it's just a general principle of law, basically, that you cannot arrest someone for a crime which isn't expressively in some sort of statutory provision, right? So you cannot make up a crime and then arrest the person. It has to be very well defined and established in an actual piece of... So void for vagueness, like I said, based on the First Amendment, and but basically just legal theory in general, you have to have a bill to arrest a person. And a part of this is the idea of ex post facto law. So basically, a law made after the thing has already taken place, right? So it doesn't go back. If something is made illegal tomorrow, you're not going to be liable for something you did today. Obviously, you cannot have a legal system without that. Abolition criminals, I put this here because to me it's a bit surprising. Obviously, this doesn't apply at all to the United States, and they're not going to recognize that expression. It's just that in the United States, if a conduct is legalized, then you are not entitled to be set off automatically. This comes up a lot when people talk about marijuana decriminalization. If it was made illegal tomorrow, there would have to be an active effort by the government to pardon people and to purge the records of people who have been convicted of marijuana possession or marijuana dealing, because those convictions will not go away automatically like in our system. They would stay in the books. Basically, the only exception to this is when a certain statute is considered unconstitutional and basically has no validity. It never had any value, so basically anyone convicted under unconstitutional law has to be set free and has to have their records cleaned. Aiding and abetting is basically when you participate in a crime. This is a bit different from our system in Brazil. It's closer to other systems in Europe, where basically the penalties will vary on how much participation you had in the actual crime itself. So in Brazil, it's usually the same penalty to everyone who contributed to the crime, no matter how small their participation was. There's just going to be a difference, in how the judge determines the sentence. But in the United States, there are, even legally at trial, because, the trials are much longer and more complex, there's a difference in how you're charged, depending on whether you were the main defendant, the main defendant, or you're just aiding and abetting someone else. Yeah, basically you cannot aid and abet someone by accident unless it's gross negligence. This is all, things that are in the American statutory provisions. So you have recklessness, gross negligence, but you have to have this intention. So intention is very important in general for American criminal law. Intent, there are different levels of intent actually. That's why there's such a big difference between premeditated murder and just manslaughter, which manslaughter just means killing someone by accident. So when you speak about vehicular manslaughter, you're talking about killing someone by accident in a motor vehicle accident. That's the meaning of manslaughter, which is different from homicide, which is intentional. Yes, so the accomplice, this is different from aiding and abetting because your participation is much greater, right? So aiding and abetting, maybe you just sold the person the gun even though you knew they were going to commit the crime, or you sold them maybe a lockpick, whereas the accomplice was actually there and helping you commit the crime itself. So there are different grading levels for people when they actually create a criminal and participate in a criminal action. This is different again because all these things are just statutory provisions and they're much looser than what we have here because, like I said before, when we speak about criminal law in particular, there is this idea of creating philosophies which encompass every possible situation imaginable so that they will not become tyrannical. Whereas in the United States, they're a lot less afraid of that because there are jury trials. So basically the idea is, well, it doesn't matter if the law is a bit too, obviously it cannot be extremely vague, but the law doesn't have to be as detailed as possible because if the situation is unfair to the defendant, then they will be protected by the jury trial. That's why the jury trial is so important, because it protects the individuals against the state, because they're going to be trialed by people who are normal people, they're not public officials, they're just a cross-section of the community. Yeah, so basically your role determines how great your sentence is going to be. Yeah, this is something I talked about in our first class. If you look it up online, or most texts that talk about this, they're going to talk about the adversarial versus inquisitorial system. But the reality is almost all democracies are leaning towards an adversarial system. So the idea of an inquisitorial system, I can't really think of any country that's a democracy that has really a very strong inquisitorial system. Basically, all countries today are adopting adversarial proceedings, both in civil and criminal law. And the role of the judge in an American trial is also different, obviously. There's a lot of liberty for case management, which is basically determining deadlines or having control over the court, especially in civil litigation, and we'll look into that. There's also a reduced role because the judge is never the one who determines the guilt of the defendant, right? Because it's always going to be a jury trial. So it's always going to be the jury who's going to rule guilty or not guilty. This means the judge has, the liberty to act in a way which is very strange to us, because a lot of judges in the United States are elected, and it's very common for them to deliver closing statements when they're delivering the sentence after the verdict. So sometimes they'll have this speech where they condemn the actions, and to us that's a bit strange. But it's because they're presiding over the trial. They're not really conducting the whole trial. So really, the people who do the most important decisions are the jurors. The judge usually only decides on the sentence and does case management. So basically, if there's any objections being made by the prosecution or the defense, basically something like hearsay. Hearsay testimony basically means when you call a witness to the stand and the witness says, I heard about that happening, or I heard rumors, that's hearsay evidence that's not admissible in court. Or you can have an objection where you say, basically this witness you call them as an expert witness, but they're not an expert. That's another objection that the lawyer or the prosecution can make. And then the judge is going to decide whether that's going to stand or not. So plea bargaining, already explained, really problematic and criticized, but sort of integral to the system. Sentencing has to be done, obviously, according to the law, but there's a lot of leeway, even for some unconventional things. But usually, because there's this electoral system with the judges, there is sort of an incentive to be as harsh as possible, because you often see campaign ads for judges where they're like, I sentenced this many people to death, or I gave this many people a life in prison, because those things play well with the public, and if you're an elected official, you want to have the appearance of being tough on crime, because that's very advantageous. Yeah, so accomplice liability, I've already talked about this. A statute, this is very important, and I'm going to talk about this again in the future. A law passed by a legislative body, okay? Never say there's a law that says that, or there's a law that says that. Law is the conjunction of all norms, all decisions, all statutes, the Constitution itself. Whereas the statute is just one singular piece of legislation. That is a big difference in terms of terminology that you cannot mix up, because it's going to give away the fact that it's going to lead to confusion if you confuse the terms statute and law. But we'll talk about that again in the future, and this is actually going to be in our very last lesson. So basically, the federal statutes and the state statutes, municipal ordinances, and I say ordinance because the municipalities in the United States are not really part of the constitutional system. They exist at the discretion of the states, you know. If you have a small state and you want to say, well, all municipalities are abolished, the whole state is going to be governed by the central legislature. That's something you can do because really the Constitution is only concerned about states. It doesn't really talk about municipalities or counties. So it's about the United States. So there isn't this idea of like municipal autonomy being protected. So really what you want to look out for are federal and state statutes. At the municipal level, you know, it's more ordinary things. So it's more mundane things, which is why you call it an ordinance. The United States Code is a big compilation of every single federal law. You're going to see this being mentioned a lot. And it basically is just a compilation of laws because legislation tends to be a bit sparse. America, there isn't this idea of having this systematic, you know, philosophically consistent piece of legislation. It's more of, you know, we feel like criminalizing, or we'll prove this, or we'll prove that. And as a result, especially in the area of criminal law, there is a multitude of criminal statutes in the United States. You hear that even from attorneys in the US, where they're not really sure how many criminal statutes exist overall, because there's so many pieces of legislation. Some states, they have had the same constitution for hundreds of years. So basically there are statutes in the books that have been there for such a long time, and they haven't been invoked in a long time, so it can be confusing sometimes. So here are some names for criminal activities. Larceny and theft, so taking property without force. If you use force, it's a robbery. Burglary is breaking and entering into someone's home, usually with the intent of actually committing a crime, because the crime of just breaking and entering doesn't require the intention to commit an initial crime. You just break and enter into someone's home, that's already an offense, and it's called usually breaking and entering. Drug offenses, obviously very famous, responsible for a lot of imprisonment sentences in the United States. Motor vehicle theft, this is where the expression Grand Theft Auto comes from. You probably heard that before. Assault, this is important not to get this mixed up. Assault is a physical thing. If you hurt someone else, if you harm them physically, that's assault. It's not, you know, robbing someone. That includes sexual assault. So it doesn't have to, you know, be this extremely overtly physical violence. It could be this sexual violence as well. Constitutes assault. So sexual assault or physical assault. Robbery, basically taking property by force. So DUI and DWI, like I said, driving under the influence or driving while intoxicated. That can be both drugs and alcohol. Most states today treat this as a felony, and usually there's a zero tolerance limit. But in the past, it has been treated as a misdemeanor. Vandalism, basically, you know, destroying property for just no reason. White-collar crime is important. We use the exact same expression here. Basically, you know, these non-violent crimes, financial crimes such as, you know, corruption, stealing intellectual property, a lot of crimes related to securities exchanges, right? So insider trading, which we'll review during the corporate law class. Embezzlement, fraud, so a multitude of crimes. Domestic violence would be basically violence that happens in the context of your home, your family. Basically, you know, you're assaulting your spouse, you're being abusive, even emotionally abusive towards your children, physically abusive. Sexual assault, you know, I basically explained any sexual activity, even if it seems minor, that occurs without the consent of one or more of the parties involved. Homicide, you know, killing a person intentionally or with reckless disregard, right? It's going to depend on the level of negligence. These things vary on state-by-state basis, so there's not much sense in getting too much into detail in a language course. Then identity theft, basically stealing someone else's identity, usually for credit card fraud or something of that kind. Hate crimes, well, like I said before in the constitutional law class, Hate speech does not constitute a hate crime because it's protected speech. But a hate crime would be then assault, basically destruction of property, or even homicide that is motivated by hate. This is really just more of a criminology aspect because the hate speech part itself is constitutionally protected in the United States. Cybercrime, basically any crime that takes place through the use of computers or online. Basically get into some sex crimes. You have sexual assault, sexual abuse. Sexual assault and sexual abuse would be something that wouldn't perhaps could be considered not as severe. It's going to depend on the jurisdiction, on the bills. Obviously, there's a move to criminalize these things more harshly now. But basically, usually penetration basically just is rape. Whenever there's forced penetration, it's rape. Where you have things like groping or forced sexual penetration, and sexual abuse is a more broad term. Sexual harassment it depends on the jurisdiction if it's going to be a crime or not. Because, like I said, this is going to be regulated by state law. Statutory rape is basically sexual activity with a minor. And this is going to be determined by what's called the age of consent. In the United States, it ranges from 16 to 18 for different states. And basically, anyone beneath that range, even if it's beneath 18, in a state like California, is unable to consent. There are exceptions. You have something called Romeo and Juliet laws when people are close in age. But some states have no exceptions whatsoever. So basically, it doesn't matter if the child appeared to consent or not, or if you knew or not. That's why it's called statutory rape, because it's imposed by the law, and the particular facts of the case don't matter that much. Sexual exploitation of a minor would be something that it doesn't involve rape by you, but maybe using that child for sexual pornography or some other type of sexual exploitation. Then incest is interesting because it is considered a crime in many jurisdictions. In Brazil, it would be problematic to turn this into a crime because of our idea of what constitutes a legitimate criminal provision. But again, the Americans don't really have that problem. I think most people in the United States would agree that there's a legitimate state interest in preventing incest from happening, especially because, in the context of a family, it can be abusive. So yes, that's incest, which is considered a crime in some American jurisdictions. Then you have sexual harassment. Like I said, it depends on the jurisdiction. This can be something, that doesn't even have to be physical. It could just be verbal or emotional abuse in a workplace or some other kind of professional setting. Indecent exposure would be just, being naked in public, basically. In particular, if you do it intentionally, if you're at a nudist beach, obviously it doesn't count, but, if you're in the subway or someplace where there's an expectation of, not being exposed to that kind of thing, then it counts as indecent exposure. Here are some white-collar crimes. Embezzlement means that you're a public official and you take public funds and you sort of keep them to yourself. So if you're entrusted with the property as a public official and you keep that property in defiance of the law, that's embezzlement. Fraud, it can take many forms in basically false advertising. That's one way. Or just a scam in general. Someone calls on the phone and tells you you won the lottery, that can constitute fraud. Bribery would be if you're a public official and you receive money, basically the same idea here, to do or not do something you're supposed to do as a public official. Like here, it doesn't really apply to the private sector too much. Money laundering, this is important for us. Basically, money laundering means you take money that is illegal and illicit in origin, and you give it the appearance of legality. Maybe you set up a fake business where you're making a loss, but at least you're sort of turning that dirty money into clean money. It could be just a front business. You could be the lottery. You could be flooding the lottery with your illicit money in order to make some legal money through the lottery. Even if in the end you lose some money, that's money laundering. Insider trading, we're gonna look into it during the corporate law class, but basically, if you have privileged information that you should disclose to the public, and you use it to trade securities, so basically trade stocks. If you're like some sort of executive, and you have some information that the public should have to know, and you use it to manipulate the stock and to buy it before the information goes public or sell it, then that can be considered insider trading. So the regulations are pretty complex, and it's not a very simple matter, but that's basically the gist of it. So you're going to have to look into the specific regulations, and the SEC in the United States, which is the Security Exchange Commissions, is in charge of that. But we'll discuss that during the corporate law class. Cybercrime, I've already explained. Intellectual property theft, I've already explained. Basically, a few crimes here. Assault, assault and battery, which are really the same thing. It depends on the jurisdiction, again, because it's several different states, so you have to be familiarized with some different terminologies. Reckless endangerment is interesting to us because it's a criminalized conduct that can basically come from even if you don't injure anyone. So if the speed limit is 40 miles an hour and you're driving at like 110 miles an hour, that can be considered reckless endangerment, and you can go to prison for that. Because if you were to hit someone, basically anyone, it would probably kill them and yourself at 110 miles an hour. Abortion, again, I have to include this, even though this is relatively recent. This has started to be a crime in the United States again. It was decriminalized completely in the 70s, but it changed recently because of the Dobbs case, which I mentioned in the constitutional law class. So it's a recent decision by the United States Supreme Court, but basically the individual states now have the power to criminalize abortion again, and many of them have started doing that. This is interesting here. This is the majority opinion. So this is the opinion that prevailed in 2003 in the Lawrence versus Texas case. But basically it's saying that there's no rational basis, right? So similar rational basis review for a law that criminalizes homosexual relationships, basically, because that's what sodomy means. Basically any homosexual act, or even some things which aren't homosexual, but which are, conventional sex acts. So conventional penetration could be criminalized under sodomy, but it's usually referring to homosexual conduct. Basically what they said is there's no legitimate state interest to be pursued by criminalizing homosexuality or sodomy. Justice Scalia dissented. So this is a dissenting opinion. Dissenting opinion is basically an opinion that was defeated in the final vote. But the justice, the Supreme Court, still felt that he wanted to have his voice heard, so he still wrote an opinion, even though it's not a legally binding opinion. But it's still good, to learn law and to learn about how judicial thinking works. So basically, he's basically saying that these moral things have always been accepted as a rational basis. Also, more things that are considered immoral by the public could be a rational basis for criminalizing certain behavior. He was defeated, but this just shows you that there's a difference in the way we perceive criminal statutes here and in the United States. So basically laws against bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, is basically saying all of these things are only illegal because of the morality, right? Including bestiality. Bestiality just means having sex with animals, basically. And this has very long been considered a crime in the United States. And, adult incest, also a crime. Obscenity, remember when we spoke about obscene language and obscene speech not being protected under the First Amendment. In fact, it's not only not protected, it can be criminalized by a criminal statute. So basically, that's just, the basics of crimes, the criminal provisions in the United States. The more interesting thing to us, I think, is criminal procedure. We'll have a look into that, right? So this is some case law here. I was looking into some Eighth Amendment case law because this is the most interesting. I think I actually skipped them. But basically, the punishments that are possible in the United States are the ones we're familiar with, right? So imprisonment with the addition of a life sentence and the death penalty. So when you're looking at Eighth Amendment case law, you're looking at a case law often limiting the ability of the state to execute people. So I was going to mention some of that case law, but it's so much case law. In each case only deals with one specific limitation. So I left some of it listed here, but really if that's something that interests you, you should look into it because there's a lot of case law regarding the death penalty. So one case decided that it cannot be applied to minors, the other one that it cannot be applied to people with cognitive disabilities. So basically there's a whole patchwork of case law regarding the death penalty in the United States. I guess I'll see you in class 6. All right.